Hi there, my name is Noelle Villanueva. I'm going to present the Pearson versus Janlin Circus Party Limited, also known as Stardust Circus, case today. Our agenda is we're going to go through our introduction, the facts on the case, the issue, our judgment, the reasoning behind the judgment, followed up by our analysis and a follow-up on the case. This is an international case, so some pertinent case information is that this is a country of origin case based out of Australia. The court will be through New South Wales Supreme Court. The judge is going to be Windyer J, and the following citation and docket numbers are on the screen. A little introduction on this case. This case is about an elephant in a circus that had been deprived of contact from any other elephants for years, until one day this elephant was allowed to be in a close proximity to other elephants, and then unfortunately those elephants were removed from the area from this one specific elephant. So facts on our case: on December 30th of 2000, Arna was an Asiatic elephant, and she was allowed to be in close proximity to 3 other elephants for a short period of time. And then shortly after, those elephants were taken away and removed from the area. To the right will be a photo you can see of Arna the elephant from Stardust Circus. Prior to this interaction, Arna had not had any other interactions with other elephants documented on this case. So the biggest concern in regards to this, and we have to look at the facts, is the New South Wales Prevention of Cruelty to Animals Act of 1979. Section 4, number 2 does show here below. It says a reference to an act of cruelty committed upon an animal includes a reference to any act or omission as a consequence of which the animal is unreasonably, unnecessarily, or unjustifiably either A, beaten, kicked, killed, wounded, pinioned, mutilated, maimed, abused, tormented, tortured, terrified, or infuriated. B, overloaded, overworked, overdriven, overridden, or overused. C, exposed to excessive heat or excessive cold. Or D, inflicted with pain. Now this specific case is looking at this section 4, number D, which would be inflicting pain on the animal. We also have to look at Section 5 of that same Prevention of Cruelty to Animals Act, and number 2 does state a person in charge of an animal shouldn't authorize any commission of an act of cruelty upon that animal. The defendant, which is Janlin Circus, admitted that they were a corporation, and during the time of the charged incident, they were in charge of Arna. And they also did authorize that 3 other elephants could be kept in close proximity to her for a short amount of time. At closing statements, the defendants did ask that the case be dismissed on grounds of lack of evidence. So we have to look at 2 big issues, and they both have to deal with pain in regards to an animal. The first one is, was pain caused by the circus to Arna specifically? And then we also have to look at how do we assess pain in animals in order to say that she didn't receive pain. So magistrate stated that the process of Arna being brought into contact with these other elephants and then them being removed from the area where she was did cause distress, and there in turn caused pain under terms related in that act noted earlier. Now, was the charge of one of absolute liability, strict liability, or one where mens rea did apply? Now we also have to look at how can we identify pain with Arna. Now this specific case did not have any information as to how they looked at it or how this was addressed, but we do have to note that recognizing pain in animals is definitely more of a challenge, as they don't communicate the same way as humans do. One of the biggest ways is to recognize a change in behavior. However, we also have to consider the other aspects of looking at vital signs, also behavioral changes, a pain scale if there's one available, and looking at the past of the animal's history to see if there's any pain associated with any previous history. The magistrate in this specific case stated that there was a lack of mens rea, which also means that there was a lack of the knowing of wrongdoing, which is quite essential in order for the prosecution to show that the action they took with Arna would cause pain and therefore show that they had knowledge that they were causing pain. So basically there was a lack of information communicated between the prosecution and the legal team showing that the circus had caused this pain strictly with their knowing of doing so. The magistrate did say that the proceedings were dismissed due to this lack of information, and the defendants were ordered to pay the plaintiff's costs. The reason for this was there was an insufficient evidence in this caseload. Therefore, the plaintiffs could not definitively show there was any intent or knowledge that the circus did perform an act of cruelty. They would have to show that in a form of evidence in a way that it would be proven through the courts. And then the magistrate also stated that the Prevention of Cruelty to Animals Act of 1979, Section 5, Number 2, was not an offense of strict liability. The judge or magistrate on this case didn't treat this case as one that a previous case was done, which is what the prosecution was hoping for. This previous case was called Dow J. and Bell versus Gunter, and it was held in October 1997, and it did go unreported. But this case did rule that there wasn't a need for mens rea in order to prove offense related to any aggravated cruelty under the Prevention of Cruelty to Animals Act in 1979, and they were able to go forward with charges on that case. Now, his reasoning was that there was just a lack of proof that the other elephants in this case also were not shown to be owned by the circus, and therefore we can't prove that they had authorized for them to be moved or even brought into the area. If we look into this case, I do want to mention that I do not support the use of any animals in a circus industry or any industry similar to it. This case was based highly on ethics versus actual facts, so we have to be careful with how things in situations like this are presented. If it's going to be an ethical case, we need to make sure we have all of our information available. We also have to know that proving pain that was caused to Arna in this is very hard to do without any clinical signs or an evaluation by a veterinary professional, such as a veterinarian. So there was no information in regards to that to this case. Also, we have to realize that proving that the circus knowingly did this act to cause harm, it's very difficult to show unless we have any kind of specific evidence talking to us, somebody's mentioning or having on video that they did do this in a way to harm the animal, then we would have proof. Otherwise, this is just a circumstantial case. And the lack of evidence in any case similar to this can only get us so far. We have to have that proof in order to show that there was pain caused. However, we do need to make sure that we continue to help with cases like this, as animal cruelty does need to be pursued, and we need to do it in a legal setting. So being able to have shown that this case was tried, even though it did not go all the way through the courts, that we are still going forward and trying to stop any animal cruelty, and will help with any legal matters we can. Just a quick follow-up, Arna, I did find some information on her. She did stay with the circus until 2007, where unfortunately she was retired along with another elephant they had named Gigi. They were both moved to a zoo in Western Plains. Now, this does come after an accident with Arna and her handler. Unfortunately, it led to his death. And then Arna spent the rest of her days at the zoo until 2012, so 2007 to 2012, where she passed away due to natural causes at the age of 54, and was cared for very well by the zoo during this time. And I just want to go ahead and put in my references here, and I also have photo references for Arna. Thank you and have a great day.